Hello there. We are live. Welcome, welcome. All of you expert legal nurse consultants and other experts. Glad to have you here. I have a scenario for you. An attorney calls you about a case. Now, when you pick up that phone, what are you doing that will help you get that case? Well, today's LinkedIn Live is going to be crammed full of the details that will get you in the right mindset with stunning insights and actionable tips to get that attorney to say yes to you and get you more LNC cases. Our speakers will share all their wonderful insight over the next 30 to 40 minutes, followed by time for questions and answers. So, everybody, get your pen and paper out, get your app up for note taking, and get ready to have a ton of information slide your way. But wait for me to give you the go ahead before you drop those questions into the chat. Now, for those of you who don't know me, I am your host, Lisa Wade, legal nurse consultant, medical record expert, and owner of Wade Nurse Consultants. Visit us at wadenurseconsultants.com to learn more about us. See if you have some subcontracting work or if you're an expert that needs to find an attorney client. Come on over, send me a message, Lisa at wadenurseconsultants.com. I'm also the creator of our wonderful LinkedIn group, the Expert Witness Entrepreneurs. Come on over, visit us in LinkedIn, check us out, see if it is a group that is a good fit for you, or just drop an E into this chat and I will reach out to you and tell you more about us. Now, I'm getting ready to introduce two experienced LNCs. There we go, Pat Iyer and Barbara Levin, who have the tips to get attorneys to say yes to you and get you more of those LNC cases. And they are going to give you all that juicy information, but they're also going to tell you some details about their upcoming convention, or I'm sorry, success conference. And believe it or not, there's the link for that. Get ready. They're going to tell you all about it. And believe it or not, it is overflowing with even more juicy nuggets of knowledge that help you crack the code for achieving LNC success. So tune in, get ready to hear more about that. But before I bring out Pat and Barbara Levin, let me scoot over to the comments and see who's visiting us live today. If you are an LNC, put an LNC into the chat, say hello, throw some likes, some hearts, some emojis, let us know you're there. And oh, we can see Allison Dixon. Welcome, Allison. And Marcia, I see you. Hi, Kellyanne. Oh, good. Melissa. Oh, you're there too. Keisha, Melinda. Oh, Deborah Lord. Everybody is here. Diane, another Deborah. Oh, welcome, everybody. Get your pens ready. Get your pens ready. There is excellent information coming your way. All right, there's too many of you. You have to say hello. All right, I'm glad you're here. All right, well, thank you all for coming, taking time out of your very, very busy days to be here with us and gather up all the good information that Pat and Barbara have for you. And now it's time to introduce them. First, there's Pat Iyer, who has her master's in nursing and is a legal nurse consultant certified. She is past president of the American Association of Legal Nurse Consultants and supports LNCs as a business coach. Pat currently helps attorneys with personal injury and medical malpractice cases. She is the author of 60 books and counting. And Pat's website is legalnursebusiness.com. Next is Barbara Levin, is certified as an orthopedic and medical surgical nurse. She is also a legal nurse consultant certified. She is also past president of the American Association of Legal Nurse Consultants and serves Massachusetts for several years as a member of the Board of Nursing. Barbara cares for patients as a clinical scholar at Massachusetts General Hospital. She serves attorneys as an expert witness for medical, surgical, and orthopedic cases. And now I bring to you Pat Iyer and Barbara Levin. Welcome, ladies. Oh,
Thank
boy.
you, Lisa.
That's a mouthful. You people have been busy. Very, very busy. I'm so glad that you're here with us today. And there's so many people ready to hear all of the wonderful news that you have for them, all the tips. And I started this event with a little scenario. An attorney calls and they are talking about a case. I know you two have tons of priceless information to drop on everyone today about getting that attorney to say yes. Are y'all ready?
We're ready.
All right. All right. Well, let's talk to you, Barbara, first. You're going to talk to us. Are you ready to tell us 3 of the responsibilities an expert has during that call?
Yes. Suggestions for you are being friendly. Smile when you pick up the phone. While you're not seeing somebody when you're on the phone, they can actually hear in your tone and your voice. And certainly it makes you feel good about answering the phone when you are smiling. Share your delight that you have the opportunity to speak to a potential client or a previous client about a case. Another tip, be genuinely concerned about the attorney. Recognize that any business person has limited resources, and your goal is to help the attorney make the best use of their resources. Another tip, I want you to think in terms of service. What can you do to help the attorney rather than what can she do to help you? Your focus should be on the client needs. And if you are not the right person for the assignment, then you can help the attorney by finding someone who is. For me, I don't dream of doing life care plans. That's not for me. I'm not qualified. Numbers are definitely not my friend. But I do have colleagues that are excellent life care planners. And so I have learned during my career that I can refer life care planners, and you can certainly use them as subcontractors, and you can still earn money by doing that.
Oh boy, I like the smile tip. But what is that song? You're never fully dressed without a smile. I'm dating myself. All right, so I'm dating my parents.
It uplifts you when you're answering the phone.
I think you're right. All right. Well, Miss Pat, do you have any more advice about what responsibilities they have during that call?
I do. There are four more points that I wanted to share with you. And the first is to believe in yourself, to know that your clinical skills are rooted in your experience, and the attorney is relying on your ability to be analytical as an expert witness in evaluating a case. Confidence is critical, and coming across as confident in that initial phone call is key. We all have, as healthcare providers, this little invisible hook that says, oh, you need me? Oh, you're asking for my help? We went into healthcare because we wanted to help other people. We want to be helpful. We want to be needed. We want to be liked. We want appreciation. And that can be a problem in a phone call from an attorney who is looking for the lowest services with the least amount of expenditure. Sometimes attorneys will ask an expert witness on that initial phone call, well, what do you think? And there's a difference between answering a question based on your knowledge and helping steer the attorney in the right direction versus giving a free service like the attorney who says, well, do you think you could do a quick research study for me on this question? That's a billable work, and that's not something that you should be offering for free. You have to believe confidently that you're going to get the case. If this is a case that is within your lane, as Barbara just said, Barbara wouldn't take on a life care planning case, but she would take on a compartment syndrome case because that's right up her alley as an orthopedic nurse. If you are inexperienced, that will come through the phone if you hesitate and if you sound unsure of yourself. And the attorney is taking a leap of faith by hiring you. There is so much at stake in the cases that attorneys are handling. When you get experience and you begin to realize all of the costs associated with filing a claim, with taking depositions, with court fees, with writing briefs, with all of the billable time that goes into handling a case, it's a huge investment. And that attorney wants to feel as if they are putting the case in capable hands. And the fourth point is that the attorney can't help the attorney unless the attorney hires you. Reiterating again that what you have to offer is your knowledge and skill, and you have billable time to offer. If you give away your time, if you don't charge for billable services, if you don't make sure that that attorney sends a retainer and a signed fee agreement, then you're cheating yourself.
Mm-hmm. Oh, I like that. Hey, our time is worth money. I like that. Now on to the questions when we're on the phone with that attorney. Barbara, what questions should an LNC ask that attorney about a new case?
I suggest that everyone design some type of template for receiving those phone calls. And in that template, you would include the name of the attorney that is calling you. What are they looking for? Certainly networking with other colleagues. If you are a brand new LNC, you can inquire from them as to what they have found successful. So that way the information that you're taking in is consistent. Questions that you're going to ask will include the who, the where, the when, and the what, such as who's the plaintiff? Who's the defendant? Where did this happen? When did this happen? When do you need my assistance? What's your deadline? What kind of case is this? You want to collect as much information as you can, and this requires really good listening skills. These questions will also help you determine and rule out whether there's a conflict of interest and determine what the attorney's needs are and how you can be of benefit to the attorney. You can then structure your dialogue and a solution, and the discussion enables you to bring the attorney to the next level of action, and that's to commit to sending you the case. So, questions that you want to ask the attorney, you don't want to ask yes/no questions. You want to engage them in open-ended questions on this initial contact so you can be clear on what the problem is. What do you want to achieve, as an example? Or what would help you move forward with this case? What role do you want me to play? Are you looking for me to be the expert? Are you looking for me to locate experts for you? Are you looking for me to write your chronology? How can I best serve you? So those are several examples for you.
Oh, good. I like the idea of preparing ahead of time those questions so I don't feel frazzled. So I like that. Definitely. Now, Ms. Pat, let's get on to talk about similar cases. Talk to us about how sharing stories about similar cases could fit into that a call with that attorney.
The attorney wants to have the confidence that you're knowledgeable about the clinical issue associated with this case. And also, as Barbara mentioned, making sure that you are the appropriate expert for this case. Is this something that fits within your clinical experience? Have you encountered this type of scenario before? Do you understand the principles and the standards behind how healthcare providers should address that problem? You can weave in a discussion or a mention of how you've helped attorneys with similar cases. By showing that you are knowledgeable about that and you have experience, you reduce the attorney's anxiety about whether you're the right person and increase their confidence and improve the odds that you are going to be selected as the expert. You do have to approach discussion of similar cases, keeping in mind whether these cases are resolved, which means that you can talk about them, or not resolved and still open, in which case you would be violating confidentiality by discussing that case with a new attorney over the phone. I've also found that when I can connect my clients to another attorney who's handled a similar case, that they really appreciate that. I can say, Joe Smith handled a similar case. I was his expert on the case. And here's how to reach Joe if you would like to talk to him about the case. And they appreciate that because there's often hidden knowledge or strategy or tactics that the other attorney is willing to share with them. Now, of course, this works well with plaintiff attorney to another plaintiff attorney. It might not work so well with me telling a plaintiff attorney that a defense attorney handled a similar case. The defense attorney may not be willing to give any assistance to somebody on the other side of the bar. And if you are inexperienced and you have not handled a similar case, you can talk about how you have managed the care of people with those same clinical needs as a staff nurse or as a critical care nurse practitioner or a nurse practitioner in another level or type of specialty. So the goal is to increase the attorney's confidence, establish rapport, listen, and then as you're listening to the details, think about whether you've been involved in a similar case and bring that into the conversation to help boost your credibility.
Ah, well, it sounds like similar cases is a good way to show off what you know and sometimes who you know. So I like that too. Now, Ms. Barbara, we're going to scoot over and talk about ethics now. Can you explain to our listeners how ethics comes into play when we have these attorney calls about a case?
Well, if you have an independent practice, plaintiff attorneys may contact you and ask you some questions. And they may give you a brief scenario and they may say to you, do you think this is a viable case? Well, they're asking you from a medical perspective. Well, as I became more experienced as a legal nurse consultant, I heard hundreds of medical malpractice scenarios, and I got more work because I could say to the attorney, based on what you've told me, without seeing the medical records, that does not sound like this is going to be the best case in your practice. And you may be better served putting your resources into other cases. And I'd like to give you a couple examples of that. I had been contacted a few years ago about a scenario in a hospital that a patient was getting ready to be discharged home. She was half dressed and somebody came up from transport came to pick her up to bring her for a cardiac catheterization. The patient said, I'm not supposed to have a cardiac catheterization. I'm going home. That's not what I came in for. Well, the transport person insisted that she get on the stretcher. The nurse sent her off to the catheterization. And unfortunately, she actually died on the table. I'd been contacted by the defense team Well, there's many wrongs here, as you can hear in my voice and hear in the scenario, that nobody's validating what the patient is stating. Nobody's listening to her. Nobody checked the armband. Nobody checked the chart. Nobody checked the physician order. There are so many issues here. So when I responded on the phone, and their question to me was, do you think that you can help us defend this case? And I politely and had explained to them the reasons that I would not be able to work on this case because there were so many failures in the system. Now, on the flip side, I had been contacted with a scenario of an individual who had been admitted to the hospital as a trauma patient, had spent several days there, and decided to sign out against medical advice. The patient did not want to stay in the hospital anymore, did not want to take any blood thinners where the blood thinners were recommended, so he would not develop a deep vein thrombosis or pulmonary embolism. And he went home, and 5 days later, he ended up passing away from a pulmonary embolism. The plaintiff attorney called to say, well, the family is very upset with the hospital. They didn't prepare him well enough to go home, and he had a pulmonary embolism and died. Well, this is one of my clinical fortes, of course, orthopedics. And I was explaining to the attorney about signing out against medical advice, making the choice not to take the blood thinners, and explain those pieces of information to the attorney. Both attorneys, both the plaintiff attorney and the defense attorney, after those communications, they actually called me, and I've worked with several cases with both of them again. So I encourage you to, certainly make sure you are smart and listen and respond appropriately and ethically to the questions.
Mm-hmm.
I just want to point out one thing. By doing that, you're saving the attorney time and money too. Time and money that they're not retrieving all the medical records and paying the costs of all of that and sending it out to multiple people for review. So this strategy demonstrates the power of personal responsibility because I have the expertise in that space, and I realize that I bring value to the table. So I don't encourage using that strategy unless you have the expertise and experience to offer these reactions. Mm-hmm. So I encourage that of you.
Well, it's right. I hear what you're saying. It is important to tell these attorneys the truth of what actually happens, not necessarily what they want to hear.
Exactly. And you shouldn't feel that you have to accept work from every single attorney that calls you. You need to listen and determine if this is the case for you or whether or not you can help them find the expert or the person that is appropriate to work on the case and subcontract.
All right. Well, we're up to what kind of clients that these attorneys are. So I'm going to talk to you, Ms. Patter, ask you about what a desirable attorney client looks like.
The vast majority of attorney clients are desirable, Lisa. It's the undesirable ones that we tend to focus on more, using the Pareto principle that 20% of your clients give you 80% of your headaches. And Barbara will identify as well as I some of the undesirable attorney clients. The desirable ones respect you. They appreciate you. They're coming to you because they specifically have worked with you before. They have been recommended to you by a colleague. They want you. They're loyal and they keep coming back to you for help. I ran my full-time LNC business in New Jersey for 28 years. Some of the attorneys who started with me 28 years ago, before I sold the company, continued to give me work for 20, 25 years. They were loyal. They came back with cases. They went from one law firm to the next law firm, and they contacted me when they moved and changed positions, as well as some of the paralegals did as they moved around. They said to the new law firm, you need to work with Pat. She's got great experts. She'll take care of you. The desirable attorneys pay their bills on time. They do not complain. They do not quibble. They do not nickel and dime. They don't attempt to reduce the size of your invoice. They don't attempt to negotiate the payment terms. And the desirable clients also take the long view. Maybe you made a mistake, and that mistake was something that affected the attorney. We are not all perfect all the time. But the loyal client says, okay, that was a problem. You recognized how it happened. You fixed the system, and I trust you with additional work. Whenever we had a system issue in my company, we would make that kind of an investigation, and I would write a letter to the attorney as well as talk to the attorney. Yes, that was a problem. We found out why it happened. We have corrected it. We appreciate your patience in the matter. I had to write those letters, maybe once or twice a year, but always use that as an opportunity to shore up the system so that it wouldn't recur. So those are the pieces of the desirable clients. They respect you, they pay their bills on time, they're loyal, and they take the long view, and they understand that when they keep you happy as their partner on their team, then you produce the best work and you're loyal to them. And one final thing, Lisa, is that occasionally when plaintiffs would call me and they seem to find me as a legal nurse consultant and start telling me their story, I would occasionally say to that person, you're looking for an attorney in Philadelphia. I have a law firm that I've worked with. I will give you the name of the attorney and the phone number. You can talk to them to see if they might be interested in taking your case. And in one situation, I got a very, very thankful letter from the attorney after he settled the case for $250,000, which literally landed in his lap because I made the referral.
That's excellent. Those sound like good attorney clients. I like that. Tell us though, Ms. Barbara, you're gonna tell us a little bit more about those undesirable clients. Maybe that word comes up.
Well, you can sometimes spot those red flag behaviors at the time of the initial contact, and when that attorney is actually contacting you to discuss a case. So you want to learn to avoid those types of attorney clients. Often the attorney will object to the terms in your fee agreement. And there's trouble ahead when the attorney starts, trying to talk you out of critical terms in your contract. Maybe it's your fees. Maybe it's the timing of payments.
Mm-hmm. Well, tell us.
Retainer.
I'm sorry?
It could also be your retainer. He doesn't want to send you a retainer.
Mm-hmm. Well, we don't like that. We don't like that. Tell us a little bit more about maybe a negotiator. What is that?
Well, I'm going to talk to you about the dictator.
Oh, I'm sorry. My apologies.
It seems like, well, the attorney is the client, and the plaintiff, let's say, is funding a medical malpractice case. And the attorney, as an example, will say, I'll just have my client send you the retainer. He will sign your fee agreement too. Well, here's the problem. This violates our ethical codes to work directly for the plaintiff, for that client, for the attorney's client. For example, we can't screen cases for people that the attorney is not representing. I've received phone calls from lay people saying, I'd like you to look at my medical records. I think I've been wronged. Well, I'm sorry, I can't work with you. I'm not an attorney. I'm a legal nurse consultant. They need to hire the attorney. The attorney's the one who hires you. And then you say, well, this is different. The plaintiff does have to be an attorney. As I mentioned, your client is the attorney. So your client is the one who has to fund handling the medical malpractice case. And as the LNC, you do not want to, and you should not have to pursue a plaintiff to get your bills paid.
Oh, okay. That was the dictator. I would like to avoid that. So how about our negotiator?
Well, the negotiator is similar to the dictator, except that the dictator is much more rigid. The negotiator can pop up at any point in your relationship with an attorney. The negotiator feels that, particularly if that individual is a trial attorney, as vast majority of our clients are, that it's his or her job to negotiate terms with you, to question your fee agreement. I'll give you an example of a woman who called me saying she was representing her mother who was abused and neglected in a critical care unit. And already I'm thinking, critical care ratio of 1-to-1, 1-to-2, maybe 1-to-3. How can that person be neglected in a critical care unit? The attorney said, I've looked at your fee agreement and I have two concerns. One is that it says that you may raise your rate. I have to agree for you to raise your rate. Well, no, my fee agreement says that I can raise my rate at any time and that it's across the board for all clients when I make the decision to raise my rates. You don't get a choice when you go to a restaurant. And if you've been in a restaurant recently, you may notice the prices are higher. The tips are now 20 to 25%, no longer 15%. You don't have an option or a choice about what you pay in the restaurant or the airline tickets that have gone up significantly either. No one says, may I have your permission, Lisa, to raise the plane ticket rate? So I explained to the attorney that I didn't have any immediate plans to raise the rate, but what my policy was. And then she said, and it says here in your fee agreement, this is my second objection, that if it becomes necessary for your company to retain an attorney or a collection agency, that the agency will collect outstanding fees. She said, I would insist on having an independent arbitrator. Well, I'm thinking, lady, you haven't even hired me and you're already worried about how we're going to resolve a conflict over fees. So I replied that we rarely had to use a collection agency and that in order for us to work together, she needed to sign the fee agreement. And she hung up on me. And that was okay because there was no match there. There was no good fit. I didn't have confidence or trust in her based on her reactions. And she obviously was suspicious of my fee agreement and me. Another negotiation tactic I'll share with you is that attorneys may object, as Barbara said, to the retainer. I shouldn't have to pay a 10-hour retainer. Well, there are some small cases where it's not going to take you 10 hours to get through the assignment. But in general, most cases use up at least 10 hours. So those are your fees. I met a physical therapist in Manhattan at a New York Trial Lawyers Association meeting, and he said, Pat, when an attorney questions my fees, I say, my fees are my fees are my fees. And I don't negotiate.
All right. I like that. I like that tact. I think I'm going to adopt that. So, Ms. Barbara, let's tell me a little bit about a bully attorney.
Well, first, are you so hungry for work as a legal nurse consultant that you would say yes to an attorney who asked you to provide certain services, such as they treat your rates as if they're suggestions, not firm statements? And they may ask you, can you do better? Well, no, those are my rates. You're thinking to yourself, but you may also want to say, oh, gee, I wish I could even charge you more. But obviously, you would not be saying that.
Not out loud.
No. And what if the attorney is treating you like a commodity and you know that they're hopping from LNC to LNC, searching for the person who's going to pop up with the unreasonable demands, that they would give in to those unreasonable demands and charge less for their services or do things that perhaps another LNC may not do. They may ask you to drop what you're doing to meet their immediate need, yet take months and months to pay your invoice. That doesn't sound too good.
No.
They may want a detailed invoice breakdown, and then they come back and they say, you know what, you shouldn't have spent so much time on the case.
Mm.
Perhaps they may tell you that you have to reduce or delete your final bill because they didn't settle the case for as much as they wanted to. Well, what you're charging as an LNC, those are your rates. It has nothing to do with what the attorney in the end, whether they get a settlement, a verdict, your rates are your rates.
Yeah, that's my new favorite term. My rates are my rates are my rates. So,
Correct. Stand firm.
like that. All right, Miss Pat, tell us a little bit about what is a tire kicker and how do we manage those attorneys?
I think the expression comes from the automobile industry with people who are evaluating the quality of a car by kicking on the tires. I don't know what that proves. In human form, when that person is contacting a legal nurse consultant, that's often a phone call from an associate or a paralegal. And I have heard this phrase, I want to call you to ask how much you charge per hour. Well, can you tell me a little bit about the case?
Mhm.
No, my responsibility is to find out what your fees are. I've gotten a list of experts and I'm just going down the list to find out what people charge. Often they're not that blatant, but that's behind the tire kicker. They are evaluating the expert purely on the basis of rates, like you are a commodity. You are charging X, this person charges Y, the third person charges Z. There's no consideration for your experience, your education. You are being evaluated strictly on numbers. When that individual is looking for the cheapest supplier, often that is not the desirable client that we just talked about before. That is a signal that a tire kicker can become a negotiator, a bully, or a dictator. So you can provide your information, you can schedule your follow-up call with that person, and it may be that you will get the case, but there's a warning flag that comes up when somebody first off the
Ooh, are we a little
how much you
frozen?
charge.
Oh, there. We're there. Oh, good. We were a little You froze a little.
Okay,
Okay.
so that's the warning signal. When the first question is, how much do you charge? You are listening to a tire kicker and you are being evaluated as a number.
Mm-hmm. Well, that sounds like something to avoid, and I'm gonna do that. All right, Miss Barbara, tell us a little bit about listening for transition statements. What are those?
Well, these are statements that you make to indicate that you understand what the attorney needs are and that you're positioned to help. You're testing to see if the attorney is ready to move forward to the decision phase. So the attorney answered your questions and gave you all the necessary information. And now it's time to transition to the decision. So this is the time where you want to show your expertise and how you can help reduce the attorney's pain. For example, here's a transition statement. You suspect the attorney, you expect the hospital has tried to hide records that would support your client's claim. You need an expert familiar with the ins and outs of electronic records, especially how information can be concealed within them. That's one of my specialties. So here I am, the LNC, coming to assist the attorney. As you're speaking with the attorney about your services, recognize that the attorney, he wants help with his problem. The problem causes pain, and you, the LNC, are offering the solution, or you, the healthcare provider, are offering the solution. Identify the attorney's need. Why is he calling for the legal nurse consultant? What is his pain? For example, the attorney may be facing a court-imposed deadline, and the judge has told him, You have till September 30th to produce your expert's report. The attorney is busy. Other things and items have grabbed his attention. Suddenly, it's September 2. He calls you and he says, I don't have an expert on this case. A very high level of pain and emotion can be associated with that phone call. And you, the LNC, are hearing that in his voice. Envision the attorney calling you, almost begging you to assist them because the timeline is short. Can you please help me get somebody? That attorney says. He identifies the timeline. Well, I know Pat, as well as myself, we have received many of those types of phone calls. So a natural transition for you to say is, well, what we found out during this conversation is that you need the expert to get that report written. And if you don't get the report written, what will happen? Let me take care of this for you. Let me find the expert. Let me have him review the records. Let me get this done for you. So you are taking that problem off of the attorney's mind because he's so stressed that there are times that he's so stressed that he can't close the deal. But by you helping to lift the stress off his shoulders, oftentimes they're going to be relieved and accept that assistance and hire you.
Mm-hmm. I like that. You know what they need, and you can help them get those needs met. That's what we do as nurses all the time. Right?
That is what we do. And helping the attorney identify, and as the LNC, you know that there's several consequences if an attorney misses a deadline. And that could include legal malpractice for that attorney for missing the deadline on an otherwise very good case.
All right. Excellent. Well, Ms. Pat, tell us a little bit about objections. What are some of the common objections that we might meet when we're on that call with the attorney?
There are several that you've heard or you will hear, and they often center around the fee issue. After making those transition statements, you're listening for the attorney's concerns, the pain points that the attorney exposes in that conversation. Then naturally the question evolves to, what are your fees? And this is an area where you may encounter objections. I will cover a couple of the objections and how to handle them. I have on my website at legalnursebusiness.com a document that is 47 ways to get the attorney to say yes to using you, and they are ways to handle objections. The objection that you hear more often than not is, oh, you charge that much per hour? The objection is to the fees, the high fees, as perceived by the attorney. Remember that your fees are based on your educational experience, your credentials, your degrees, and it's important to stand firm in your fees. I have a coaching program called LNC Elite, and last night one of the people in the program asked me about a conversation that she had with an LNC company who wanted to hire her as a subcontractor. This individual in my coaching program has a doctorate. She's a critical care nurse practitioner. She's experienced, and she was offered $35 an hour to review medical records. She asked the person, is that negotiable? And the individual said no. And my person said, well, I'm sorry, I can't work for that. That's less than nurses are paid to work in the hospital as staff nurses. That's not an acceptable rate. So they agreed to disagree and ended up the phone call. So those are the things that you should consider and look at. Are you charging a fee that's reasonable for your experience, your expertise, and to stand firm for those people who will attempt to negotiate your fees downward?
Mm-hmm. Well, you all have given so much wonderful, good information, and it looks like maybe it might be time for a little Q&A. And Are you ready for that now?
We sure are. But first, I think we'd like to tell our viewers about our conference coming up March 23, 24, and 25, and give an overview of that, and then see what we stirred up in the audience.
Oh, good. Tell us all about that conference.
This is taking place online. It is the 7th time that Barbara and I have collaborated to plan a legal nurse consulting conference. We started in July of 2020, and we've been offering 2 conferences a year since then. This is a combination of a boost in knowledge, support, and networking. It can be isolating to be legal nurse consultants and experts separated from other people who think the way we do, who view the world the way we do. So Barbara and I have created this vehicle to bring in business experts, experienced legal nurse consultants, and attorneys to share content that will help build the businesses of legal nurse consultants. Barbara, do you want to share a little bit about some of the topics that we're planning to cover?
Absolutely. We have exciting topics, and those include mastering your magnetic message. And this will actually help you bring in new clients and increase your business. How will you create abundant referrals? You will learn more about that. We have some amazing experts who are going to share their wisdom and knowledge, some very experienced legal nurse consultants who will share, as well as advanced practice nurse. We also have a physician who will talk about a program on plastic surgery, and Pat can share a little bit more about that. And we want to offer you a new avenue for legal nurses on where to practice. And that can include working together with your board of nursing and or working with the attorneys that are bringing cases to the boards of nursing. You will have the opportunity to network. We have a lot of fun. There's always great surprises during the conference. So if you are looking for the conference on ways to build your business, network, learn more about expert skills, other areas in legal nursing, and so much more, we are the conference for you. And you'll have that opportunity to hear from so many who have increased their business, gained more clients as a result of attending our conferences. March 23, 24, 25, 2023.
Oh, I love the idea of networking and finding out new streams of income. That is always wonderful.
Perhaps, Pat, you might want to talk about our so-called keynote speaker, the exciting criminal story that will be revealed.
Yes, I had the experience of working on the Charles Cullen case, who is the nurse who is serving 7 lifetime sentences for systematically murdering patients in the hospital. He was the subject of the Netflix movie that just came out in the fall called The Good Nurse. I was hired by one of the prosecutors for a very interesting assignment. We knew that Charles killed patients. We knew he worked at the hospital that the prosecutor was concerned with, and we knew people died in the hospital. And Charles at that time was working in a critical care unit. So it was our role to determine which patients he killed. Also in this presentation, I'll bring in Dr. Kathleen Ashton, who is a doctorally prepared nurse who served as an expert witness on one of the cases, and she'll share her role, because not only were there criminal cases against him in the hospitals where he worked, but there were also civil cases brought by the families against the hospitals who employed Charles and then passed him on to the next unsuspecting hospital without sharing their concerns about his behavior and some of the things that he was caught doing. The link, by the way, that's running along the bottom of the screen is where you can sign up for the conference. It is case sensitive, so make sure you use the capital letters in this link as you are going there to get your seat.
Oh, it sounds exciting and so enthralling. I can't wait for people to sign up and get all of this extra information that you have for them, Pat and Barbara. Uh, can I see if there's any questions on the way? Are you ready for questions?
We're ready.
All right, let's take a peek in here. Oh, well, we have Deborah who says that conference sounds really exciting. So she is ready. I hope you're signed up, Deborah. All right. And let's see. I'm trying to look. I'm going through, seeing if there's any specific questions for Barbara or Pat about the conference, about getting more LNC clients, about uh, anything that they can help you with. Well, maybe we're still waiting. Maybe they're still getting ready to add that to to the comments. Any more news on that conference? Anything else exciting? Any hints of what the surprises might be?
Oh, they wouldn't be surprises, Lisa, if we told you what was coming.
I understand. All right. I
One,
understand.
one of the unique things that we've been doing all along in our conference is offering networking opportunities. Small groups, large groups, and some wonderful connections have been made during these times. We've heard from several of our attendees that because of the networking from the conference, they've gotten their first case, or they learned how to do something new from someone else. They're walking away from our conference after they've attended with so much information, and then they're taking the steps to follow along in how to build their business. So it's so exciting for us to hear from our attendees afterwards and what they've done with their business. So this conference is for every level legal nurse consultant, from the beginner to the most experienced. So we welcome all of you.
Well, you've given so much information today, so much good information. It's hard to imagine that this conference is going to be crammed full of even more information.
It will be. I see a question here from Liz about what do you think about negotiating your rate as a subcontractor? Sometimes you have the ability to negotiate. Often it is restricted. A rate is established for subcontracting by the organization who's hiring LNCs as subcontractors, and they may not have room to maneuver. They may be charging the same rate to the client for all of the LNCs who are working on a project. So that's fixed. But it never hurts to ask, because if you don't ask the question 100% of the time, you're going to get a no. If you do ask, you have the opportunity to potentially increase your rate. And that can add up, particularly if you're doing a lot of hours for a particular company. Melinda's also asking, if you attend live, you can select the VIP rate in order to get the recordings. The VIP rate gives you the live option as well as the recordings. You can also purchase only the live ticket, at which point you will not get the recordings, or just the recordings. We do encourage you to come live, and we do encourage you to do the VIP rate because you have extra sessions with a full hour at the end of the first 2 days for questions and answers with me, and other special benefits of being a VIP, including the recordings.
Right. Okay. That is good information. I like live versus recordings. I like the options. All right. Do we see any more questions right now? I don't. They could be coming up, but ladies, tell us how people can reach out to you after we're done today. What is the best way to reach you, Pat and Barbara?
Well, you can reach me at patier@legalnursebusiness.com.
Excellent. And Ms. Barbara?
And you can reach me at Barbara at barbarajlevin.com.
All right, that's good.
And Denisha is asking, if you choose the recorded option for the conference because of work, would you still have opportunities to network? No, unfortunately, you will be looking at a recording. You won't be able to participate in the breakout rooms or the chat. You would have the ability, because we record the chat and download the chat, you would have the ability to see other people's comments and information in the chat, but you wouldn't be able to respond in real time. And Barbara, there's a question here from Catherine Everett that I think would be appropriate for you to answer.
If you are behind the scenes as a consultant, is it a conflict of interest if you are working with an attorney against the corporation in which you work? The attorney assured the LNC they won't be a testifying expert. Yes, it is a conflict. You do not want to get involved with anything against your corporation, your workplace. I have seen that happen. I had been contacted about things, inquiring if I could be the inside person against an association that I'd worked with. And that's wrong. I mean, that's really ethically and morally wrong to even accept working on something such as that. So I caution you not to do that.
Think of it as, don't disrupt your food chain. Even though you've been told you'll be confidential, it can get out, and you've got inside information about that company, that healthcare system, that could benefit the plaintiff attorney if you're working for the plaintiff attorney, but it is a clear conflict of interest not to take a case involving your healthcare facility and, by extension, other facilities in the same chain. Even if you're not working directly for them, there's a sister hospital, that's still a conflict because you're getting your paycheck from that corporate entity.
All right. Well, yes, that's an ethical question. You talked about ethics earlier. So I definitely see that as a conflict. So
Absolutely.
I think the questions are kind of petering out. I don't see any more coming up right now. Oh, hey, is it poor form? Oh, I got one. There's one from Marcia. Is it poor form to work a case where you are a patient at times, or sometimes a patient's there?
Barbara, you want to address that one?
I don't think that's a smart thing to do. Perhaps you're meeting the people, perhaps they're the nurses that are taking care of you. And then I don't know what side you are working on, whether it's the defense or the plaintiff side. But if you're the plaintiff side and you're being treated at a facility that provides your care, perhaps you've run into these potential defendants, the nurses and the doctors, and they've provided your care. I don't think you'd want to do that.
Yeah, I would agree. Think about if you were going to a family practice doctor and a plaintiff attorney asked you to work a case involving your healthcare provider. That's a simpler example.
Mm-hmm.
You wouldn't do that. You know, Dr. Bob's been taking care of you for 10 years. Would you want to help a plaintiff attorney sue Dr. Bob and expect that Dr. Bob's going to be friendly when Dr. Bob finds out that you're involved in the case? I see it as a conflict as well.
Mm-hmm. Well, Diane has one comment about the conference. If anyone's on the fence, I attended the last one. Very much worth it. Learn from these two ladies. I think that's excellent advice.
Thank you, Diane.
Well, I think we are getting down to the last minute here. If there's any more questions, or if anybody, if you have any more nuggets of information, ladies, to tell us about.
Well, please see our link below. We'd love to have you attend the conference. You have our contact information if you have any questions, and we look forward to seeing you.
All right. as ever, it's a pleasure dealing with the two of you. And you have such good information. It looks like everyone's had a wonderful time. And maybe we'll do this again another day.
Thank you, Lisa. It's been a pleasure. We love to share this information. And I think my parting message is to stand firm in your value when you encounter the undesirable attorneys. Be clear on what you have to offer. And if you say no to a bad deal, which we encourage you to, know that there's another attorney out there who will pay you what you're worth and will appreciate your help. That's my parting message.
Oh, well, thank you again. Valerie says it's a great presentation. All right.
Thank you, Valerie.
All right. Well, thank you. Let's do this again another time. Thanks, everybody, for coming, and get to that conference. Sign up today. All right. Thank you, and see you next time.
See you next time.